Hey, hello everybody. I forgot to switch on the camera. So that's why you entered into a blank screen, but we are on the go right now. How's everybody doing? Hopefully everybody is good and you're excited to be joining us today. You know what? This has become my favorite activity of the week. I mean, I cannot believe it's Wednesday already, but here we go. So, as you probably already know, every Wednesday we are here and we are doing our live prep for SQE1. So I see we've got some people joining us live today. Thank you guys for coming in. I hope you enjoy the show. Put us a message in the chat that we've got on the right hand side of your screen. So I know that you guys are here, and let me know what you're preparing for. I'm guessing the majority of people watching this are going to be preparing for SQ1 in the July sitting, having just survived the awful weeks of SQ1 in the January sitting. So we probably have a bunch of people who are just gearing up on their prep for the July sitting. Now, some exciting news for the channel. I have finally completed the entire set of FLK1 and FLK2. I was trying to put together a video that covers every aspect of FLK1 and FLK2 to give people the opportunity to either have an introduction to the topics that they need to prepare, or alternatively, if they're revising, to have an opportunity to have a revision of each one of the topics. Now, FLK1 is a little bit easier for me because these are the stuff that I've been teaching all these years. FLK2 is a little bit trickier. So I had to do videos on what happens to you if you're arrested and you're in a police station. I hope it doesn't happen. I have videos on property practice. I've got videos on a whole bunch of to assist you guys in your preparation. So I think this is going to be fun. Now, all of these are getting released on a weekly schedule, which means that you can see all those videos, the entirety of FLK1 and FLK2, straight away if you're channel members. If you don't want to become channel members and you don't want to buy me a coffee every month for $2.99, then you can wait as they're getting slowly released. So eventually, all this material is going to become available to everybody and for free. But in the meantime, we're starting off by giving them as a thank you to our channel members. All right, guys, are we ready for some contract law? Woohoo! Is a bit of an easier topic than the one that we had last week. Last week, we were dealing with some dispute resolution things that are a little bit trickier. But this week, we are deeply into the topics that I like. So hopefully you're going to like them yourselves. Now, one of the side issues here is that the topic being enjoyable doesn't necessarily make it easier. So I want you to enjoy the topic, contract law, for instance, and commercial and business law, but I don't want to create like a false sense of security here. You still have to revise all that stuff and bring your knowledge up to spec so you're able to deal with all the issues properly. Thank you to the new guys who signed on. As I said before, drop us a message on the chat to say hi so I know who's here watching us. And if you are watching this on the replay, feel free to leave messages down in the comments, and then I will reply to all those comments so we can start and kind of get an idea of what people are doing and what they're here for and how they're enjoying these sessions and so on. So are we ready for some multiple choice questions on contract law, remedies, damages, and all the rest of it? I'm going to try, as I always do, to share the slides. Now, this works on occasion and sometimes not. Let's see what's going to happen. And if you see me looking to the side, it's because I've got an iPad there watching myself talk. So this is how I know that you guys can still see stuff. By the way, if anything kind of falls down, if the quality deteriorates, or if the sound's not through, or if the quality of the visual is not good, let me know in the chat and I will panic because I don't know what to do to fix it. But okay. It seems that it's fine so far. So let's get cracking with question one. Da-da-da. So this is our scenario one, ladies and gentlemen. So in our scenario one, Ella hires Prestige Events Limited to organize a high-profile charity gala. The contract specifies that Prestige Events must provide a luxury venue, catering for 200 guests, and live entertainment for the evening. However, on the day of the event, the venue booked by Prestige Events is double booked and is forcing the gala to be moved to a less prestigious location. In addition, the catering arrives late and the entertainment cancels at the last minute. Not a good set of things, yeah? As a result, several guests leave early and the gala raises only half the expected funds for the charity. Now, Ella is pretty pissed off and she wants to take legal action against Prestige Events for breach of contract and is considering the remedies available to her. So, the question for you: which of the following remedies is most appropriate for Ella to seek damages, and under which circumstances might the court grant it? Actually, hang on, I misread this. Which remedies are appropriate for Ella to seek, and under which circumstances might the court grant them? It could be damages, it could be something else. So let's see our options. Option A, damages. Ella can claim financial compensation for her losses, including the reduced funds raised by the charity as a direct consequence of the breach. 2, specific performance. Ella can compel Prestige Events to rehost the charity gala at no additional cost, as this would fulfill the original contract terms. C, get an injunction. Ella can obtain a court order preventing Prestige Events from taking any new clients until they compensate you for the breach. Is it restitution? Ella can recover any fees already paid to Prestige as they failed to provide the agreed services. Or is it rescission? Ella can cancel the event, cancel the contract, and be restored to her pre-contractual position, recovering all payments made to Prestige Limited. So is it A, is it B, is it C, is it D, or is it E? Let's have a think. I vote for... What's the correct answer? I vote for A, damages. Ella can claim financial compensation for her losses, including the reduced funds raised for the charity as a direct consequence of the breach. Okay, now let's clear up the ones that are wrong. Now, this is an event that has gone wrong and somebody has suffered financial losses as a result. B is offering specific performance. This isn't going to help because the thing has already happened. Specific performance is a remedy that one can consider if they're looking for performance ahead, or they're looking for something that has not taken place that could take place in the future to repair the problem. But a scheduled event that has gone wrong, like this one, cannot really be fixed by specific performance. So this is not the appropriate response. Now, an injunction wouldn't really help us here either. Injunction is a good idea when you're trying to compel somebody or prevent somebody from doing something. Here, the issue is how to compensate for what has gone wrong, as opposed to force them to take one action or another. Now, would restitution be appropriate? No, because restitution is looking backwards, is only looking for compensation for expenses that somebody had. But here, we don't only want expenses. Ella also wants some loss of profits, income, the amount of money that she was going to generate from the gala. So restitution is not appropriate. Now, rescission, which means that you get out of the contract, again, is not the issue here, because we are talking about damages. We're talking about some damages allow us to get compensation for something that has gone wrong. It's not so much getting out of the contract. The contract's dead anyway. So what should you do when you're faced with a question like this? You need to remember that the primary remedy always for contract is damages. So the number one thing to think about is always monetary compensation. Yes, there are other types of remedies available for breach of contract, but the number one consideration will always be monetary compensation in the form of damages. And the motivating idea behind this is that damages allow you to claim both for expenses that you've had in preparing for something, and also they look forward. Let me ask you a question. What do you think is the primary mechanism for assessing damages for breach of contract? What is the primary tool? If anybody knows this, you can stick it in the chat. But in the meantime, I'm not going to let you wait. I'm going to tell you. The primary tool that we use to calculate damages, we call expectation loss. Why is that? Because expectation loss is trying to place us where we would have been if the contract had been properly performed. If you want something to compare this to, think about the system for compensation in the law of tort. Tort looks backwards. Tort is compensating you for harm that happened to you for the expenses that you had. Contract is not about this. Contract tries to put you, damages for contract, try to put you in the position you would have been if the contract had been properly performed. That's why the key measure is forward looking. And the key measure is expectation loss, which would allow somebody in Ella's position to both get compensated for expenditures she already have, but also to get compensation for where she would have been. Where would she be if the contract had been performed properly? People would have had a good time at the gala, and they would have contributed more in terms of charity donations. Now, if you're thinking this is too speculative and how could we possibly tell how much people would contribute in donations, don't worry about this. We've got cases in the law that even calculate the chances of somebody winning a beauty pageant. Yeah. So the fact that it might be a little bit difficult to estimate loss of profits or where you would have been if the contract had been properly performed does not preclude you from claiming. You can still use case law that backs up these calculations so you can get to your intended point. But look, this is getting perhaps a little bit further away from what you need to know in the context of this exact multiple choice question. So to recap, Ella has got a problem because of the breach of contract by Prestige Events. There's no doubt here that there's been a breach of contract by Prestige. The question is, what would be the appropriate remedy? The problem here is money and getting adequate compensation, placing Ella where she would have been if the contract had been properly performed. Therefore, answer A is the correct answer. Damages. Okay? So hopefully everybody's happy with this and this makes sense. If this makes sense to you guys and you're enjoying this, hit the like button so I know that this is coming through, okay? And let me know what you think either in the chat, or if you're watching this in the replay, put a comment down under the video so I can tell whether people are enjoying this or not. Are we ready to move on to our next question? Let's see. Okay, we've got another question coming up. Alrighty. New question. Scenario 2. This is about a holiday gone wrong. Do you guys find this stressful? I find this very stressful. I find traveling stressful in general. Messed up holiday arrangements even more stressful than anything else. By the way, if you want to participate in my current disagreement with Booking.com and go to Gate for them canceling my flight and then me being pissed off for a few years, go to my LinkedIn page and see what that fuss is all about. Okay, now, this question, scenario 2, is about Amira. Amira books a 2-week luxury holiday with Paradise Getaways Limited to celebrate her 10th wedding anniversary. The package includes a 5-star beachfront resort, all-inclusive dining, and access to premium spa facilities. Upon arrival, Amira discovers that the resort is under renovation. The pool and the spa are closed, the dining options are limited to one buffet-style restaurant, and construction noise disrupts her stay. While the overall cost of the holiday was £5,000. Amira, though, is not only upset about this, but she's also upset about the disappointment and emotional distress that was caused by the ruined anniversary trip. So she wants to file a claim against Paradise Getaways for breach of contract. Question for you guys. Can Amira recover damages for her non-pecuniary losses? And under what circumstances are such damages available under the English law of contract? Okay, is the correct answer? Yes, Amira can recover damages for her emotional distress because the purpose of the contract was to provide relaxation and enjoyment. And, Paradise has breached this purpose. Is it B? No, non pecuniary losses are not recoverable under English contract law as damages are limited to financial losses. Is it C? Yes, Amira can recover damages for her emotional distress, but only if she can prove that Paradise acted fraudulently or negligently in failing to deliver the promised services. Is it D? No, Amira cannot recover damages for emotional distress because the loss is not quantifiable and only direct financial losses are compensatable. Or is it E? Yes, Amira can recover damages for emotional distress, but only if she can demonstrate that the breach caused a personal injury or physical harm. Ta-da! So, if this has happened to you guys, and I wish it didn't, but it tends to happen, do you think you would be able to recover damages for your non-pecuniary losses? Go on, let's be brave. Put in the chat whether you prefer A, B, C, or D. Let's see if the chat works. A, B, C, D, or E. What do we have here? Okay. Come on. Show me something. If you don't want to venture a guess, just give me an emoji. Who's gonna give me like an emoji in the chat? Right. The correct answer here. What's the correct answer? The correct answer here is again A. Yes, Amira can recover damages for her emotional distress because the purpose of the contract was to provide relaxation and enjoyment, and Paradise Gateways has breached this purpose. Okay, now, can we generally obtain compensation for emotional distress or disappointment for breach of contract? Quick answer is no. Generally, we cannot claim compensation for emotional distress and disappointment for breach of contract. Why not? Because otherwise it would be mayhem. And one of the common problems, one of the common mistakes that students early in the study of contract law tend to make is because they're not exactly sure what happens with emotional distress and disappointment. And very often I see questions in exam papers that kind of go, there's been this breach of contract. We calculated the damages using expectation loss, as I told you before, up until a certain level. And then at the end of it, they stick and £1,000 for their disappointment, which kind of loses them quite a great deal of marks, right? Because you just cannot do this. So let's go through the wrong answers here and then I'll come back to it. B was saying non-pecuniary losses are not recoverable. Damages are limited to financial losses. Well, no. The base position is that non-pecuniary losses are not recoverable, but there are not extreme, but special situations that the law will allow it. So it's not a blanket restriction on non-pecuniary. That's why B is wrong. C says that Amira can recover for emotional distress if she proved that the others were nasty. No. The recovery for non-pecuniary losses is not dependent on the motivation or the behavior of the defendant. It's dependent on the type of contract that you had. So B is wrong, C is wrong. D is again a sort of blanket restriction on it, which is again wrong. Is it a problem if it's not quantifiable? As I told you earlier, difficulty in quantifying stuff does not preclude you from claiming them. So it might be difficult, I will agree, but it is still possible to get it. So that's why D is wrong. And now E, yes, she can recover for distress if there was personal injury or physical harm. Yes, she could, but this is not the only situation. Now, what are these special cases that will allow you to bypass the rule that is against non-pecuniary losses? These are cases where the core purpose of the contract is to give you something pleasurable. Think of cases like Jarvis versus Swan Tours from 1973, or Farley versus Skinner from 2001, where the courts get to discuss this. If you're having a general contract, you order a phone, okay? The phone arrives broken. It is a breach of contract. You are entitled to compensation. Can you also say, oh, I really, really, really wanted this phone, and now I was so pissed off when it arrived broken, and I'm devastated, and I want some extra money? No, you cannot, because this is a normal consumer contract. The purpose of the contract was not to get you to be happy. So in that general style contract, recovery for non-pecuniary emotional distress is not allowed. But if the whole purpose of the contract was your enjoyment, like you booking a holiday, okay? The whole point of the holiday is to have a good time. So surely there has to be some level of compensation that goes on top of the financial elements that you were missing. So if then Amira went to a resort that she couldn't sleep at night because it wasn't comfortable, and the room was not appropriate, and the catering wasn't there, and the pool was not accessible, we could compare this in the normal way that we do when we're assessing damages and say, what was her expectation loss that she would have all these material elements with her booking? How much are these material elements worth? Well, let's look at what a hotel that wasn't offering all these functions would cost. And then we can find a price difference between one and the other. If you go to a 3-star hotel that does not give you all-inclusive food and gives you like a terrible room and is next to a highway, it's going to be cheaper than the luxury hotel that she had booked. So we can find the difference in price in material delivery between one and the other. But in addition to this, because the contract is meant to give her pleasure, we can quantify this. How much do we give for the disappointment and distress? That, unfortunately, I don't have an answer to you. It is up to the trial judge. And you will find in these holiday cases that every time the trial judge quantifies it, if the case makes its way to the Court of Appeal or the Supreme Court, they never mess with the judge's quantification of this. So the question is always a matter of principle. Is this the type of contract where we can compensate for disappointment or emotional distress? It's never about how much money the judge gave it. And, this being England, they don't give a great deal of money. So don't think you're going to become rich just by claiming for your emotional distress. So, to wrap this up, yes, Amira can claim for the material elements that were missing due to this breach of contract. She can also claim some money for her emotional distress. Why is this? Because everybody can always get it? No, it is because this is a holiday contract, so it falls within these limited circumstances in which the law allows recovery for purely emotional distress. If you had physical inconvenience, you were physically hurt, then that's something else. They will always compensate you for this. But the focus of the question here was the emotional distress. All right. Are we ready for the next question? Yes. Come on. As I'm switching slides, throw us an emoji in there. I can see there are quite a few people connected, but there's not a great deal of activity in the chat. So go on, throw us a bone there. Just give us an emoji. Where are we? We're back. Okay. Righty. Scenario number 3. Are we ready for scenario number 3? Today we're dealing with breach of contract, contractual performance. Hey, I just saw, maybe I don't see the emojis because they're flying around. Thank you, guys. I saw a little heart flying around. That's awesome. Right. So we have a breach of contract and remedies that we're discussing today, damages, assessment of damages, types of damages, and all of that stuff. Now, scenario 3, Mia. Mia owns a bakery, and she enters into a contract with Frost Tech Limited to supply a new industrial freezer for storing her cakes. The freezer is delivered, it's installed, but due to a defect, it breaks down after a week, spoiling 3,000 pounds worth of ingredients and cakes that are stored inside. That's not very good at all, is it? Now, as a result of the spoiled stock here, Mia is forced to cancel several catering contracts, resulting in 10,000 pounds in lost profits. Additionally, Mia has signed a lucrative contract to supply wedding cakes for a prestigious event. This would have significantly boosted her business reputation. She claims an additional £5,000 for the loss of the opportunity to gain new clients from the exposure. Mia seeks to recover all these losses from Frost Tech, arguing that they were caused by the faulty freezer. Right, so what's going on here? Mia gets the freezer. The freezer's messed up. It destroys her cakes, and it also denies her the opportunity to engage in further business. So now she wants to recoup all those losses from the people that are responsible for this breach of contract that she claims is Frost Tech. Fair enough. With a question. Under the principles of remoteness and causation in English contract law, which of the following losses is Mia most likely to recover from Frost Tech? A, all three. The spoiled ingredients, the lost profits, the loss of opportunity, because they all stem from the faulty freezer. Is it B, only the cost of the spoiled ingredients? Because this is direct and foreseeable consequence, but not the others. This is B. Is it C, the cost of the spoiled ingredients and the lost profit from the cancelled contracts, as both were foreseeable consequences of the breach? Is it D, only the lost profit, as the loss of ingredients would have occurred regardless? Or is it E, none of the above, as Frost Tech cannot be held responsible for losses beyond the defective freezer itself? Aha. Okay. Thank you, John. John has been brave enough to submit a possible response. Okay, John says C. Does everybody agree with this? We have, and I'm drinking from my favorite San Francisco mug today. Yes. All right, let's see. John says C. C is the cost of the spoiled ingredients and the lost profit from the cancelled contracts, as both were foreseeable, but not the loss of opportunity to get more clients. Now, why is that? Yeah. In fact, you are correct. The correct answer here is C. Let's take a step back and think about what the limiting doctrines, as they're normally called, what the limiting doctrines of causation and remoteness are about. If you're trying to get compensation for breach of contract and you're seeking damages, which is monetary compensation, you need to think about how far you can take your claim. Now, clearly, a causal relationship between what is happening and the loss that you're suffering is necessary. But causation is a necessary connection between the different elements, but it's not a sufficient connection. That's why then we go through the doctrine of remoteness. Now, causation would mean that the freezer is broken. I have to buy a different freezer. I need to get food to replace what happened. Now, if I do something random in relation to this. So, I book myself a spa because I was so upset that the freezer is broken that I needed something to make me relax. The spa is not really causally related to the breakage of the freezer. Now, new freezer, new food, replacement of the items that were lost are causally related. Me sitting around in the spa is not. So if we break the chain of causation, then we cannot claim for something. But even within the chain of causation, there needs to be a limit as to what people can claim. Now, my favorite example here is you order a taxi to take you to the airport, right? So you booked the cab and you said, I want you to be here at 7 a.m. tomorrow morning to take me to Heathrow because I'm catching this flight that leaves at 9 a.m. And I've given the taxi company the details of the flight and everything else. Yeah. Now, the taxi, in breach of contract, fails to turn up. Consequences. I have to find an alternative way to get to the airport. So I run to the tube because I cannot find another taxi, and I get to the airport with a tube. I arrive late. I miss my flight. I need to book an alternative flight. I managed to get an alternative flight, but I arrive at my destination hours later than I was meant to. Because I'm hours later, I miss a business meeting. Because I lost the business meeting, I come back here, I tell my boss, I get fired from my job. Now my wife finds out that I've been fired from the job and she kicks me out of the house. So a few months down the line, I'm living under a bridge. Right. Not cool, right? All of these things are causally related. The taxi, the replacement, like the tube ticket, the replacement flight, the meeting, the loss of the job, the divorce, the bridge living. Causally related they may be, but don't you think it would go too far if you were asking the taxi company to compensate you for the totality of those losses? Yes. So the doctrine of remoteness works with a couple of distinct ways. Direct losses, things arising directly from the breach, are always compensated. How do we know that something arises directly out of a breach? Is that this would have happened to everybody. If everybody would suffer the same additional costs, or the same additional items as costs, if not the exact amounts, by trying to find alternative performance, these are then directly arising losses. Yeah. If people need to get to the airport, they need to get another way to get to the airport. If they miss the flight, they need another flight. But not everybody who goes to the airport takes a flight goes for a business meeting. Some people go on holiday. Some people go to see family. Some people, just go for fun. Okay. So even though we understand that everybody needs an alternate way to get to the airport and everybody needs an alternate flight if they miss their flight, not everybody has the same consequences that I would have suffered. So the first part of the remoteness test is directly arising losses, doesn't cover everything. Then we got the second part of the test. The second part of the test says what? Things that are within the contemplation of the parties. So then you can blame people for stuff that are causally related to the extent. That's the post coming in. It sounds like an earthquake. So you can only blame for people for extreme things that would not have happened to everybody if you told the other party about it. Yeah. So remoteness. Keep this in mind. This is like once you figure it out, it's actually quite easy. Things that would have happened to everybody, they need to be compensated. Things that do not happen to everybody but happen specifically to you, you can only blame the other party if you had told them about it, if it was within the contemplation of the parties. If you guys want the reference, this comes from the case of Hadley versus Baxendale from 1854. Don't you love it how contract law is still to be found on all these kind of ancient Victorian cases? I think it's super funny. Right. So that's why the correct answer here is C. Mia can claim the cost of the spoiled ingredients and the lost profit from the cancelled contracts, because this is a loss that would have occurred to everybody. Frostech knows that they supplied a business industrial level freezer for somebody who runs a job. It is natural that somebody who has malfunctioning machinery to carry out their job will incur loss of profit or will lose clients when that machine fails to work. So if the failure of the freezer is due to a breach of contract by Frostech, Frostech is responsible for a replacement free, the cost of the replacement, the cost of the replacement food, and the immediate loss of income that stems from this failure. Now, the rest of it, they would only be responsible if it was within the contemplation of the parties. So if Mia had told them, I want the bigger freezer because I'm catering a big event, and catering the big event is such a big deal for me because catering the big event gives me the opportunity to source new clients, and they were knowledgeable about this, then it would come within the second part of the remoteness test and she would be able to claim. This does not seem to be the case from the facts of this question. Therefore, C is the correct answer, and the rest of them that are giving you different options are wrong. Okay? Are you guys happy with this? Does it make sense to everybody? If it makes sense, give me another enthusiastic emoji so I know that you're all getting it. Now, of course, I don't want you guys to be freaked out. If you're approaching this as a question in the style of the SQE, you simply have to quickly read it and pick the correct one and move on, right? You don't have to sit there and offer like a 1 hour lecture onto how the substantive law behind it works. But I'm taking these questions as an opportunity not only to see questions that familiarize you with the format of the SQE, but also to give you the background of the law in a way that kind of helps you remember what's going on, or perhaps fills in gaps with your revision and everything else. Now, by the way, if you guys want more MCQs for free on your inbox every Monday, you can subscribe to my newsletter. I'm gonna try and type this here, but I'm always terrible in typing and talking at the same time because I'm a guy and I cannot multitask. So if you email newsletter@glintis.co.uk with the word subscribe in the subject matter, then I will add you. Did I type this properly? Yes, I think so. I will add you to my mailing list. So every Monday, you will receive a multiple choice question in the style of the SQE. And then the week after, you're going to get the answer to this and a fully articulated explanation as to why the correct answer is correct and the wrong answers are wrong. I do this every week for my community. You're also welcome. Follow the links that you see down in the channel. We also have a Facebook group where we get to talk with each other and meet other candidates and so on. So we can all prepare together, because the worst thing that you can do for SQE is to be sitting by yourself and agonizing and freaking out. I know that some of you are in prep schools already, so you've got a community of people suffering through the same experience. But just in case we've got any people who are self-studying in the audience, live, or if you're watching this in the recording, and you're feeling a bit lonesome and you're feeling a bit kind of left out, joining communities such as these ones in these live streams, or joining the Facebook group, or becoming members of the channel are all opportunities to connect with other people who are having the same experience. So, it can get pretty lonely out there in the world of SQE preparation. So we are trying to get together to the extent possible. Are we ready for our next question? Let's go. Let's see what the next question is. Scenario number 4. We are breezing through this today. Yeah. So we have question number 4. Sophia enters into a contract with Lux Events to organize a luxury gala. You see, I've got a gala theme going on today. So the gala is for her company's annual celebration. She agrees to pay Lux £50,000 for the event. As part of the contract, Lux Events promises to offer a high-profile venue. They've got Michelin-starred catering, expensive stuff, and live entertainment. Sophia spends an additional £10,000 on invitations, advertising, and decor, expecting the event to attract new clients and boost her business profile. But it all goes wrong because Lux Events cancels the event at the last minute due to internal issues, which leaves Sophia with no time to arrange an alternative venue. Not only has she lost the £10,000 she spent on preparations, but she also estimates that she missed out on £30,000 in new business opportunities from potential clients who did not attend the event. Now, Sophia is pissed, and she's seeking damages for the losses caused by Lux Events and their breach of contract. Yeah, agreed? Yeah, I would be pissed as well. Question: which of the following best distinguishes between a reliance loss and expectation loss in Sophia's claim? Aha. So we're getting into the nitty-gritties of calculation of damages. Now, A, reliance loss refers to the 10 grand Sophia spent preparing for the event, while expectation loss refers to the 30,000 in potential profits. Or B, reliance loss refers to the 30,000 in potential profits, while expectation refers to the 10 grand spent preparing. All right. Does it, as in C, include Sophia's losses caused by the breach, both including the 10 grand and the 30 grand? Now, D offers an explanation of expectation loss. Expectation loss is limited to the £50,000 contract price, while the reliance loss includes any incidental losses. Or is it E? Reliance loss and expectation loss are identical concepts. It's just to mess about, as both measure the full extent of the losses caused by breach of contract. Aha. Okay. Now, which of the following? Okay. Oh, am I trying to reconnect? What's going on here? My computer is telling me that it's losing my connection. Somebody must be digging around the street, right? Let's see if we are back. Let me try and send the share again because it seems to have disappeared. Oh, this evil technical difficulties. Why? And we were doing so well. Yeah, let's try again. Aha, are we back? Let's see if my PowerPoint is back already. So while I am fiddling with it, you can tell me what is your preferred option. So what do we have? Is it A, B, C, D, or E? Okay. I will venture a guess and say A. Yeah, does everybody agree with me? A. Let's offer a definition. Reliance loss compensates the injured party for expenses incurred in reliance on the contract being performed. In this case, the 10 grand that Sophia spent on invitations, advertising, and decor. So these were made in preparation. These expenses were spent in preparation for the event. Expectation loss, on the other hand, compensates the injured party for the benefits they expected to gain from the contract, in which case the £30,000 in potential profits. Okay, right. Which one of those is the normal measure of damages? This links up with stuff that we said earlier when we were looking, I think, at our first question. What should be your baseline? Because nobody's going to force you, right? You can choose when you go to court, you could choose to estimate your losses on the basis of reliance or expectation loss. Think about what we were saying earlier. Compensation for breach of contract is forward-looking. Where would you be if your contract had been properly performed? Where you would be in a place where you wouldn't have wasted expenditure, but you would also have gained what you expected to gain out of the performance. Now, in this case, Sophia will have met all those clients and will have the potential of getting these additional rewards by having brought more clients into your business. Would you, in which circumstances, if that's good, so if expectation loss is the forward-looking one that contains more things, why would you go for reliance instead? A reliance loss is your backup. A reliance loss is your backup when you have proven expenditure, but you cannot prove your expectation. I am launching a new video on the channel, and I think the video is great, and you guys are going to love it, and you're going to see it, and you're going to go crazy, and you're going to give me super chats, which you can do while you're on this stream, by the way. You can click the super chat thing and send me money. And I'm going to be rich because this video is so cool. And because of a breach of contract by one of my collaborators, the video never gets made or never gets completed. Right? How much was I going to make out of those super chats? No idea. I've got no way of proving it. I've got no track record of receiving these things. I've got no legitimate expectation that I would receive them, right? So in which case, I would be precluded from claiming my expectation loss because I've got nothing to offer to back up my assertion that I would make millions out of super chats. The only thing I've got that I can prove fairly easily is to show the expenditure that I had in producing the video. And perhaps I would have some normal expectation of profit from AdSense, the advertising revenue that I get out of YouTube and all of that stuff. So your reliance loss will be your backup position when you cannot prove something better. But your standing aspiration is going to be for you to claim your expectation loss. in this case here, you're not asked whether Sophia would actually be able to claim for this. Whether the reality of whether the claim would be successful or not will depend on stuff like the ones we had in our previous question, discussing causation, remoteness of damages, and all of that stuff. The question here in this scenario is simply asking you to define what is reliance and expectation loss. So for that matter, I think the appropriate answer, or the answer that gets the closest, is A. Now, while I'm saying this, everybody, if you are regulars in these live streams, or if you're members of my channel, or if you're subscribed to the newsletter, or if you've been around my videos when I'm talking about how to address multiple choice questions for the SQE, you're probably familiar with this already. But I think it's worth stating again. The way the questions are designed for the SQE, they're fairly chunky scenario-based questions with 5 possible answers that are all also quite chunky. That's why it's so unfair that you got such a limited amount of time to go through them. But anyhow, I'll complain about this in another stream. The possible answers you're going to have are not random. They most likely look legit. So your task is not to spot the one correct answer out of a bunch of garbage. Your task is to find the one answer out of possible 5 answers that most closely matches. It doesn't mean that the rest of them don't match at all. It could be that you got like a whole bunch of answers that come quite close to answering the question. But your task is to find the best possible one. So don't go into the exam with a mindset that says, I have 1 highlight correct and 4 completely wrong answers, and it's going to be straightforward to choose if I know about this area of the law. It becomes complicated because you need to work your way through possible potential answers that are a little bit correct here and there. So remember this. Remember this. And that's going to help you with your preparation when you get to it. Are we ready for question number 5? Yes, we've got more questions coming up. You're not going to get away with this that easy. All right. Okie dokie. So, switching off to question 5. While this is switching over, I'll take a sip out of my now very cold coffee. All right. Now, question 5. If this is your lunch break, is this a fun way to spend your lunch break? Are you guys kind of sitting there going through a noodle soup while I'm yapping about these things? Yeah. Or are you pretending to be at work and you're listening to this with the headphones? Right. Either option is perfectly fine by me. Just don't let your bosses catch you if you're in an open plan area. I see we've got quite a few people connected, so there's probably people kind of looking behind their back right now. Okay, scenario 5. Ben is looking to purchase a second-hand car for his delivery business. He visits a dealership where a salesperson tells him that the particular van had just 1 previous owner and is in excellent condition and has never been used for any commercial purpose. Based on this statement, Ben buys the van for £15,000. After a few weeks of use, the van unfortunately breaks down, and Ben discovers that the van had multiple previous owners, was used extensively for commercial purposes, and had significant undisclosed mechanical issues. Ben decides to take legal action against the dealership for his losses. Now, Ben should have figured out there was something wrong because he bought the van for 15 grand. Now, surely, if you buy a nearly new van in excellent condition, it should cost a bit more than that. But hey, we're not here to judge Ben. We're here to judge the dealership. So the question for you guys, which of the following factors will help determine whether Ben's claim arises from breach of contract or alternatively misrepresentation? You see, I'm giving you a nudge away from the breach of contract stuff into the topic of misrepresentation. And the reason why I'm doing this is because the two get mixed up. And they tend to come up together pretty often, and it confuses people no end. All right, let's look at our potential answers. Is it A? So, which of the following help determine whether it's breach or misrepresentation? Is it A? whether the salesperson's statement formed part of the contract or was a pre-contractual statement that induced Ben to enter into the contract. Is it B, whether the dealership acted negligently in failing to inspect the van before selling it to Ben? Is it C, whether the van's breakdown resulted in financial losses for Ben's business, which would be recoverable in a claim for breach of contract? Is it D, whether Ben can prove that the dealership deliberately made false statements about the van to mislead him? Or is it E, whether the dealership included an exclusion clause in the contract limiting liability for pre-contractual statements? Aha. Okay, John is saying D. All right. Do we have any other offers? Anybody wants to challenge John there on the D? D says whether Ben can prove the dealership deliberately made false statements. John, I'm gonna have to disappoint you. It's not D, it's A. Whether the salesperson's statement formed part of the contract or was a separate pre-contractual statement. Now, why is it this? Let's go back to what the question is asking. It's asking which of the following factors will help determine whether Ben's claim arises from breach of contract or misrepresentation. So which are the motivating things? Now, we have to be super careful with this because the same set of facts could be interpreted or could look like both a breach of contract and a misrepresentation. Let's go back to the definition of what makes misrepresentation. Misrepresentation is a statement of an existing false fact that induces somebody to enter into the contract. Statement, false, existing fact, contract. Perfect. Now, what is a breach of contract? A breach of contract is a failure to live up to the promises. Promises. What are promises? Future stuff, not existing. Future stuff. Yeah? This is your key determining factor, the key cutoff between misrepresentation and breach of contract. If what has gone wrong is that you didn't get what you were promised, then we're in the domain of breach of contract. If what has gone wrong is you were lied to about the status, the situation, the attributes of the goods right now, then we're talking misrepresentation. And also, all the other stuff. The statement needs to come before you enter into the contract and so on. Now, here, if the deal is, if you buy this van will be able to do X, Y, Z, will have these characteristics. These are the description. This is the description of the goods. And then you get the goods and you find that the goods don't meet the description. Then you're in the domain of breach of contract. If, on the other hand, the deal is before the contract, great van, the van has this, the van has that right now, right? And it tends to be a lie, then you're in the domain of misrepresentation. Now, I can hear you think that you're thinking, ooh, these things are similar. Yes, they're similar. That's why it's difficult in this type of scenario to distinguish between misrepresentation and breach of contract. It's difficult to distinguish, are we talking about the promise for the future or are we talking about the existing fact? So I feel you. Thousands of my undergraduate law students who have messed this up in their assignments also feel you. This is why we're talking about this, because this is a difficult subject. But we're lucky to be doing this in the context of an MCQ for the SQE as opposed to doing it in some sort of long-winded LLB level assessment question. Let's go back to our question. Which of the following factors will help determine whether Ben's claim arises from breach of contract or misrepresentation? The correct answer was A, because it's telling us to distinguish between separate pre-contractual statements or statements that form in the contract. B is incorrect because whether they were negligent or not doesn't really matter, okay? In distinguishing between misrepresentation or breach, the motivation for the problem doesn't matter. With the consequence of that problem also does not matter. Yeah, because C is it about financial losses or not? No, this is about the consequences. This is not about the type of violation we got. D is again about why are the statements false. We don't care why the statements are false. We care that the statements are false. Yeah. And E was about exclusion clauses. Like, that's a little bit random. I don't see how this kind of links to anything else that we're saying. All right. So the conclusion here is that the correct answer is the answer that the A, because that most closely links up with what the question is asking. Now, I've got videos both on breach of contract and performance and misrepresentation that if you have a look through the channel, you can find them and kind of have a think about these things. Are you guys enjoying the session? Give me a final emoji before I close off. So I have really enjoyed the session with you guys today. I love contract law. Is what I do most of the time in my sessions with my undergraduates. But now this is not what I'm going to do. Now I'm going to get on my bike and I'm going to go to uni where I've got a class on business law. So if you want more of this stuff, make sure to subscribe to the channel and have a look at what's coming up for next Wednesday's session. That's already pre-scheduled, so you can click the button for notifications so you don't miss it. And I'll see all you guys next week, and we can do together another set of questions. So thank you for joining me today. It was lovely to have everybody here, and I'll see you guys again next week. In the meantime, go watch the videos on the channel. Thank you, guys. Bye-bye.